to asking me questions and wanting to know what's going on with this with the charges with Ibrahim Adiba of the UDP, and this whole bit about sedition charges, and what really is the position of the law with regards to that. So I think that's what we're going to be talking about. And also there has been a lot of questions on the fact that when the UDP instituted a legal action at the Supreme Court with regards to the election results, their case was struck out because of technicality. And now people are asking, why is it that the case of Ibrahim Adiba of the UDP was not struck out, even though that was the prayers that the defense asked the court for, that the matter be struck out. So I'll just try to give my own knowledge, a little bit of expert knowledge on that. Again, like I always say, it is my opinion. It doesn't mean it is a hard and fast rule, but I'll try to break it down so that the average viewer or people watching can get some sort of an idea as to what it is. So we'll just give some time for more people to join us, and then we'll get on with that. So if you can hear me and you're watching this live, please, just share it so that a lot of people can benefit from this, and we can have a lot of interactions. I wish I could share this on my I think I can, if I just give myself a minute. Yes, let me just grab something real quick. Hopefully it's going to come on, because I just want to share this live on my other page, which is the my page, which is the Melville Roberts and Roberts page. So it's different from my Facebook account. So let's crack on. Yeah. Now, sedition. So a lot of arguments is being put forth that sedition charges are obsolete charges. Obsolete as in they don't have a place in modern day society. They don't have a place in modern democracy. And that nobody, that's the argument we see, that nobody should be charged under this law as an offense. And that, even in England and other places, the Western, in the Western world, they've basically, moved away from this charge. So why is it that we have it? But the argument, so first and foremost, we need to establish something. And that is good law, bad law, irrespective of the position that people hold, irrespective of how wide the numbers are, or how wide the section of society that does not believe that a particular law is good, the fact remains that the law is still in our statute books. And because the law is still in our statute books, it means that it is still the law. So irrespective of how people see it, irrespective of the arguments for and against it, it is still the law. It's in our criminal code. It criminalizes sedition. Anything that the offense basically says that anything, speech or publication or anything that brings into disrepute the office of the president or the government of the Gambia as established by law. Now, the fact is, this is the law. It is still in our books. Whether we agree that it should be there or we do not agree that it should be there, at this particular moment is redundant. What is important is, it is still part of our laws. And therefore, if a person is found to be wanting within that particular section or that particular provision, then they could be charged because it is still in our laws. Now, I was on UDP Bantabat today, and I said something. I said, every person, every individual, and I'm talking about the respective different party leaders that form the coalition, can be held accountable for whatever it is that we're seeing today. Now, even though some people are arguing that nobody should be charged under this law, but when the coalition government came together, even before it became a government, when the coalition came together, the clarion call was that these laws that were part and parcel of our penal code, our constitution, and things and laws that were there to enable former President Jammeh cement himself in power and to vest a lot of authority and power in him, to an extent that he was seen by a cross-section of the society and by the outside world as a dictator, and that his rule was autocratic. Now, you had the coalition government, the coalition coming together, and these were the clarion call that these laws would be done away with, that we would have a new constitution, we would have new laws. Public Order Act and such other laws had no place in our society. We in fact, we could say to a large extent that the catalyst for change was because the UDP executive was charged under the Public Order Act, which to my mind and to most people would not be anywhere near our statute books today. Now, what happened? The coalition came into existence, and we had the opportunity to make amends and change these laws. But that was not what was done. What was done, sorry, if you guys can just give me 1 second. I'm just trying to do this real quick. Just 1 second. Just 1 second. I'm sorry, just 1 second. I need to do this real quick. Just 1 second. Sorry, just bear with me. I'm just trying to share this live on my other page. Just bear with me. All right, good. So basically, when the coalition came together, they had all the opportunities to change all these laws. That should have been the focus. That should have been priority. That should have been the objective, because that was the clarion call. That was the message they sold to the average Gambian, that these laws are bad, that Yahya Jammeh is using these laws to suppress Gambians and things like that. So you wouldn't expect, you wouldn't even imagine that a law such as this one would still be in our statute books. Now, what happened was, when the coalition came together and started a government, when they became a government, I am of the opinion that it was self-interest first. It was about personality. It was an individualistic approach first, before the collective interest of every Gambian. So what did we see? We saw the amendments, the laws that were changed. The first thing we saw was the change of the amendment of the law to the age limit for who can be vice president. That was the first law we saw that was changed in our parliament. The second was, we saw parliamentarians go to parliament to change the law, to amend the law, so that, because what it used to be is that if a member of a political party loses his seat in that party, or the party suspends that individual, and that individual ceases to become a member of that political party, then that member automatically loses their seat in parliament. But because they wanted to secure and cement their position, what we saw was parliamentarians to quickly go to the hallowed chambers of the National Assembly and amend that law. And that is why now we see political parties struggling for parliamentary survival. In the sense that when now a person falls out with the party under which they ran for the very seat, or the very parliamentary seat that they occupy, they don't lose that seat. And that is why we saw a lot of defection from the GDC, from UDP, joining the NPP, the ruling party. So even though these individuals lost their membership in the UDP, they still retained their parliamentary seat. And this was to the advantage of whichever party that they belonged to. So in as much as they rushed to change that law, albeit with the support of their political party, their respective political parties, what we saw was that it is now detrimental to the survival of these political parties. So we find out now, what we see is that even political parties are struggling to hold the parliamentarians accountable, because they don't want to fall out with them. Because if they fall out with them, it continues to dwindle their numbers in parliament. And politics is all about numbers. So if you don't have the required numbers in parliament to make effective change, you don't have the required numbers in parliament to make your voice heard, it becomes a lost cause politically. Because politics is indeed, no matter what people tell you, at the end of the day, in the final analysis, politics is about numbers. You need numbers to translate policies into tangible political reality, into substantive policies. So you can have an opposition having the brightest of ideas. And I always liken that to the PDOIS party. You can have, no matter how much people say how brilliant and phenomenal Halifa Saleh is, no matter how much people say the ideologies, the ideas of PDOIS are brilliant, they're exceptional. If you don't have the requisite numbers, if you don't have the figures to turn those policies, to turn those brilliant, phenomenal ideas into tangible governmental policies, it becomes redundant. it becomes redundant. The truth is, and this goes to my political party, the truth is, at a moment and time, the UDP had the legal standing, they had the legal power, they had the prowess, they had the power, they had the political clout to change all these bad laws. But the truth is, no matter how you see it, when you are in opposition and not in government, you see all these laws and you keep saying, oh, they're draconian laws. You feel the laws are autocratic. You feel these laws are there to help the dictator to further propagate themselves and further cement themselves in power. But then, when you assume office, when the opposition becomes the government, what we see is a radically different shift. When the opposition becomes the government, what we see is a radically different shift. Because they begin to realize that some of these laws that they criticize is good enough to keep them in power. It's good enough to cement their position in power. So basically, what we saw during the early stages of the coalition was, instead of them coming and changing all these laws that they said were like laws that they disagreed on, that they call Jame laws, they begin to see these laws as what safeguards their interests. And that is why you still have, sadly, you still have the law such as sedition. So you can make all the moral arguments. You can make all the political arguments back and forth. But the fact is, the laws are still there. So today I was having a conversation with Sehu Sedili on the UDP Bantaba, and he mentioned that a particular parliamentarian said to him that, oh, we did not change these laws because we were looking forward to having a new constitution which would address all these issues. And I said to him, that was a very redundant statement. It was a very dishonest statement. Because in as much as you're waiting for the draft constitution to usher in and bring in all these progressive laws and do away with the draconian laws, but you did not wait for the draft constitution to further change and or amend the laws to suit their own interest. Now let's close our eyes and take a look. How many private member bills did we see in our parliament that was not only for the interest of parliamentarians, but for the interest of every single Gambian, irrespective of political affiliation, irrespective of ethnicity, irrespective of creed, irrespective of race, irrespective of social status? How many private member bills did we see parliamentarians pass in that parliament that benefited the entire Gambian citizenry? The fact is, we listen to grand speeches in parliament. We listen to academic debates in parliament. We listen to theoretical approaches of governance and politics and everything that goes on with it. But when it comes to tangible, progressive laws that would trickle down to the everyday Gambian, irrespective of who you are, irrespective of your political affiliation, we saw nothing. We saw nothing. So why did the parliamentarians not wait for the draft constitution to pass some of the laws that they passed to secure their own interest? Why did the government not wait for the draft constitution to pass in that same parliament some of the laws we see that would further help the government to achieve its own agenda? So the fact is, the argument that they were waiting for those laws for the draft constitution to bring in and to usher in new laws and do away with all these bad laws is such a redundant argument. Now, sedition. What is sedition? I'm going to go into the section and see if I can get the actual definition as prescribed hang on, I'm just trying to get into the code so I can just tell you what this is. Give me 1 second. So, section 51 defines what seditious intention. It says sedition intention is an intention A, to bring into hatred or contempt or to excite dissatisfaction against the person of the president or the government of the Gambia as established by law. So I want you to pay particular attention to this. Seditious intention talks about hatred, contempt, excite dissatisfaction that an individual can bring against the president, the office of the president, or the government of the Gambia as established by law. Now, so there are arguments. People were making the argument that why is it that Ibrahim Madiba is charged with sedition, but then when NPP officials insult the UDP leader, Lawyer Dabo, or other political leaders, they are not charged and brought under the same section? So now I need to make this clear, and you need to understand that my position is a position of the law. Now, if you look at the definition, the definition section of the offense, it tells you that seditious intention is an act that brings disrepute against the office of the president, operative word, office of the president, the government of the Gambia. Now, how can you bring seditious intention charges against somebody that insults, for example, Lawyer Dabo? Lawyer Dabo does not hold the office of the president. That is what the offense is dealing with. Lawyer Dabo is not the government of the Gambia as established by law. So in as much as you can make all the moral arguments, you cannot find a legal leeway in establishing a charge of sedition against any other person who decides to insult any other individual that is outside the scope of the office of the president and the government of the Gambia. You need to be the president. You need to hold that office, and somebody does something that can bring disrepute, that can excite the ordinary person, that can do whatever it is as defined by the section, or it has to be against the government. But in failure of that, you cannot bring a seditious charge against an individual for insulting another person or another individual. Now, where does the responsibility lie? The responsibility lies on the fact that, yes, even though people are making the argument that, okay, if Ibrahim Madiba is being charged on this offense, under this offense, then the person that insulted Lawyer Dabo should be charged under. No, they cannot. They cannot, because the offense clearly states that the office of the president, Lawyer Dabo does not hold the office of the president. The offense clearly states that the government of the Gambia as established by law, Lawyer Dabo or the UDP party or any other political party leader or their party is not the government of the Gambia as established by law. So we're clear on that. Now, the responsibility of the president as the president of all Gambians, irrespective of political affiliation, is to ensure that we have a level playing field where the issues being addressed would be one of political issues and not one of personalities. It is the responsibility of the president to ensure that our politics is sanitized in such a manner that insults, personal attacks would have no place in a progressive 21st century political discourse. It is the responsibility of the president to ensure that when it comes to political dialogue, when it comes to political progressive points being made in rallies, it would be reduced to issues of policies and not one on personal attacks. And if the president takes the lead on this, then we will begin to see a very sanitized political terrain. We will begin to see a political environment that is positive. It is forward thinking, it is progressive, and it is to the benefit of every Gambian. You want to see a political debate, you want to see a political discourse where different sides of the political spectrum would come together, engage themselves in issues that the everyday Gambian would be able to identify with, that the everyday Gambian would be able to see and begin to understand what they need to do, the type of leaders that they need, the type of leaders that could offer them what they see as an emancipation of their current status. But then if the politics is reduced to verbal attacks and insults, at the end of the day, it is the Gambians that suffer. It is the masses that suffer because they have no benefit between the two political wars. And it is said that when two elephants fight, it is mostly the grass that suffers. Now, let us go into the merits of the charge. Now, to my mind, I do not believe that what Ibrahim Adiba said qualifies in the manner it was said and in the context it was said, qualifies anything that would hold this particular section as an offense against him. But that is my opinion. Substantively, the merits of it will be discussed and debated in court, and it would be adjudicated upon by the courts. So I'll leave that for the courts to do. Now, let us go back and look at what happened in court. What happened in court? Now, Ibrahim Adiba was charged under section 51 of the Criminal Code. And the defense argued that you cannot charge a person with this offense because that offense is not the substantive offense. That particular section is the definition section. It is the section that tells you what it is to make such an offense. What are the ingredients that you need to commit such an offense, and how you will be found liable, and what the punishment would be if you are found liable or if you are found wanting. Now, the argument of the defense is you cannot come to court and charge a person on a definition section which is not the substantive section that tells what the offense is. So you cannot charge a person for stealing by bringing them with a charge to say stealing is when you deprive a person of his property. So you cannot go to court and say Melville is charged for stealing under section 51, and when you go to section 51 it tells you section 51 is stealing is when you go into somebody's house and you collect her purse and you walk and turn right and go front. That is stealing. No, you cannot charge the person for that. You charge a person for the offense. For the offense. Now, the court, the defense in its application to the court, in its argument, in its prayers to the court, made a case that because the charge sheet is defected, the charge sheet is not proper, because a proper charge is not before the court, therefore the case should be struck off. It should be struck out. Now, I see a lot of people being upset and angry because they are of the opinion or of the view that the case should have been struck out because the magistrate held that indeed the court agrees with the argument of the defense that the charge was a wrong charge. And therefore, it made the charge sheet become a defective charge sheet. And it means that there was no proper charge before the court. Now, the magistrate, the argument that people are making that are upset with the ruling is that he should have struck out the case. But the issue I have is that if the magistrate had struck out the case, he can only discharge Ibrahim Madiba. He cannot acquit and discharge. Because to acquit somebody, that person must have been found not guilty by a court of competent jurisdiction on the merits and substance of the case by failure of the prosecution proving their case in court beyond a reasonable doubt, which is the standard of proof that the prosecution needs to establish a criminal case against an individual. So when the court had looked at the merits of the case, looked at the evidence that has been presented, and come to the conclusion that this individual is not guilty, then that individual can be acquitted and discharged. Meaning, once that individual is acquitted and discharged, that individual cannot be tried for that same matter again in any court in that country or in the Gambia. This is what we're talking about in Gambia. Because the principle of double jeopardy, which basically just simply means in simple terms to charge a person for the same offense again, to punish a person for the same crime twice or more than once, would have kicked in. So that is why when you see certain cases, criminal cases, it would say that the accused person is hereby acquitted and discharged. When an accused person is acquitted and discharged, it brings to legal conclusion that particular matter, except in the instance where you have a process of appeal, where they can start an appeal process to appeal the decision of the lower court. But whilst that appeal is ongoing, it does not change the fundamentals that that particular person has been acquitted and discharged of that crime. So until a court of higher competent jurisdiction overturns the decision of that lower court, it still stands. Now, Ibrahim Madiba could not have been acquitted and discharged. He could only be discharged because the case was not looked at in its merit substantively. The court did not look at the evidences. The prosecution did not open their case. The prosecution did not present their case. The defense did not put up their defense. And therefore, the court cannot say that Ibrahim Madiba is not guilty and therefore he is acquitted, because they have not looked at the substance of the case. They have not looked at the merits of the case. And if the court has not looked at the merits of the case, the court can only discharge Ibrahim Madiba on the virtue of the fact that the charge sheet before the court was defective, because it was not the correct charge that Ibrahim Madiba should be charged on. Now we move to the next point. The people that are saying that the matter should have been struck out, this is my position. In fact, the decision of the magistrate to not struck out the matter makes it even better for Ibrahim Madiba, because it has protected Ibrahim Madiba from the excesses of the police. Because if Ibrahim Adiba, the case was struck out, it would mean that Ibrahim Adiba would be discharged. But that does not stop the police from now rearresting Ibrahim Adiba, subjecting Ibrahim Adiba again to a police bail where he could be held in detention for 72 hours before he could be released, and then taken to court and charged on the correct charges. I don't know if I'm making sense. I'll repeat. If Ibrahim Adiba, the case was struck out by the magistrate, immediately he left that courtroom. Remember, he was not acquitted and discharged. He could only be discharged because the substantive matter was not dealt with. So if he was discharged, he takes a turn and he bends the junction. The police will rearrest him. And remember, Ismail Adiba, as we stand now, is not subjected to police bail. So the police cannot revoke the bail of Ismail Adiba, because Ismail Adiba is subjected to court bail. Because the first thing that the defense did was to ask the court to now come in and assume the bail conditions of Ismail Adiba. So Ismail Adiba is under a court bail and not under police bail. However, if the magistrate had struck out the case, it would mean that that case had come to its legal conclusion until another fresh charge comes before the court. So Ibrahim Adiba would not have been subjected again to court bail. The matter would have ended. It would have come to its legal conclusion. And therefore, Ibrahim Adiba now can walk a mile and the police will rearrest him on the proper charges, because that would be fresh charges. They will subject Ismail Adiba, if they want to hold him in detention for another 72 hours and then bring him before the court and charge him on the proper and right charges. So the magistrate not striking the case out is to the advantage of Ibrahim Adiba, because Ibrahim Adiba is still on the court bail, meaning the police cannot rearrest him for those same charges and subject him to anything else that he wouldn't want. So in another way, if you look at it, the court was doing a favor to Ismail Adiba by making sure he is protected. Because I can tell you that the police were already waiting. If the magistrate had struck out the case, they were already waiting, and they would have been happy to rearrest Ibrahim Adiba, put him under detention. They have a right to keep him for 72 hours and then subject him to police bail. That was not what Ibrahim Adiba or his defense team would have wanted. So that is why sometimes before we rush to pass judgment, we need to look at things from a different point of view, understand it for its legal, appreciate it for its legal context. Now, what do I find problematic with the magistrate? What I find problematic in that ruling is that the court decided to instruct the police to make the proper charge. That, to my mind, was the court descending into the arena. The court should have been an impartial arbiter. It was not the business of the court to tell the police what to do. It was the business of the court to adjudicate on the substance of the matter. Was the charge that was before the court the right charge? Yes or no? If the charge is yes, you proceed. If the charge is no, you discharge Ibrahim Adiba and then you leave it for the court, for the police to decide. Because what instructing the police to come, the prosecution to come with the proper charge, is actually preempting the police. You're actually thinking for the police. You're actually assuming that the police want to charge Ibrahim Adiba with the proper charge. And that was not the responsibility of the court. What the magistrate should have done is to discharge Ibrahim Adiba and say, I have no charge before this court, Ibrahim Madiba is discharged. And then it would be the responsibility of the police to say, okay, we want to charge Ibrahim Madiba now with the proper charge. Because, maybe you don't know, but it has happened in the past where the magistrate could have discharged Ibrahim Madiba, and then the police can decide, you know what, we don't want to further charge the man anymore. The police could have said, we have no intention to further charge Ibrahim Madiba. The police could have said, you know what, let's leave it, let him go. But because the matter is still ongoing, because the matter is still before the court, the court have instructed the police to come with the right charge. So obviously, even where the police did not want to continue with the charge against Ibrahim Madiba, they have been forced by the hands of the court, or their hands have been forced by the court to come with the correct charge. And that is what I find legally problematic, because it was not the business of the magistrate to delve into the arena to make that decision for the police. But like I said, if you look at it from the flip side, you could see that it was a favor done, and it was to the advantage of the defense team of Ibrahim Madiba, because he is still under the court bail and cannot be subjected to the excesses of police power. Now, to those that were now asking, but why was the UDP petition struck out on technicality, but Ibrahim Madiba's matter was not struck out on technicality? The difference is very simple. You cannot compare the UDP petition and that of Ismail Adiba. First and foremost, they are on two different pathways. Ismail Adiba is a criminal charge. The UDP petition is a civil charge. In fact, there are arguments that the election petitions are neither civil nor criminal. Some people have gone into the extent of defining it as a miscellaneous path. But widely, it is assumed that an election petition is a civil matter. It falls under the scope of civil law. Whilst the case before the magistrate on Ibrahim Madiba is a purely criminal one. So, as explained earlier, even if the court had struck out the matter, they can only struck out the matter and discharge Ibrahim Madiba, because on the criminal law, Ibrahim Madiba could not be acquitted because the case had not been looked at for its merits, for its substance. So it means the police would have rearrested Ibrahim Madiba and charged Ibrahim Madiba again. So the two are not the same. And the Supreme Court rules on election petition states that the issues of technicality can render the substantive merit of the election petition void. So the technicality in the election petition goes to determine the heart, the substance of the issue. So that is what the rules of court state. The technicality is not a mere technicality when it comes to election petition. Because remember, election petition are time bound. The rules are very strict. It is a whole nation in waiting. It is a whole country in waiting. It is a whole electoral system in waiting. The threshold is radically different. And the heart of the matter is determined by the technicality. In looking at the merits of an election petition, the rules state that what you and I are calling mere technicality goes further to deem the merits of that case as void. The same cannot be said for the criminal matter. And last and most importantly, if the criminal matter is struck out, where the accused person is not acquitted and discharged, but merely discharged on the technicality of the form that is defected, that is in defect before the courts, then that person, there is nothing stopping the police that has prosecutorial powers to come back and charge that person, bring them before the court again with the proper charge. So striking the case out would have been to the detriment of Ibrahim Adiba. Because if that case was struck out, it meant that the case would have come to its legal conclusion at that stage. That matter would have been concluded. And the police can leave Ibrahim Adiba to enjoy his air-conditioned car till he gets to his house. They rearrest him, take him to the police station, subject him to the new charges now, charge him under the appropriate and right charge as deemed by the court, keep him there if they want to for 72 hours as prescribed by law, and then take him to court and charge him again. I hope that makes sense. Now, finally, like I said, this was going to be 30 minutes. I don't know how long I've been here even. The bit about sedition charges were there since the Roman times. It was actually instituted by the Roman emperor of those days to protect the seat of the emperor, to protect the seat of kings and queens, to protect the establishment from criticism of any sort. Now, we live in a modern day society where you cannot say somebody cannot be criticized because that person is in government or that person is in power. In fact, in England, they have done away with seditious offenses ages ago. It's not in their statute books because free speech has taken over and people have a right to criticize their government and hold their government accountable. That is what modern day democracy has prescribed. But the fact is, we still have these laws in our books, in our statute books. And regardless of how we think or how we make of it, it is still our laws. The responsibility was on every Gambian at a moment and time when the atmosphere was right. And all of these laws could have been changed. The laws that are coming back to haunt us, the laws that are coming back to bite us, they could have been changed at a time when we had the wherewithal, we had the energy, we had the receptive political atmosphere to change all these laws. But the honest truth is, as Gambians, we are mostly selfish. We think about ourselves first. We think about the individual first. Rather than look at collective interest, rather than look at country, we put our individualistic interests first. And that is why we still today, 8 or 7 years after we claim to have kicked out the dictator, we're still being beaten by the laws that we said were dictatorial. How did we come to this end? How did we get to this position? It was simply because when we had the wherewithal, when we had the numbers, when we had the support, when we had the time, energy, and resources, when we had the political clout and support to change these laws, to amend these laws, we decided that it was individual, it was self before country. So I hope that as we are going forward, we would begin to understand and we would begin to see the rationale behind having a positive, forward-thinking ideas that are for country. Country should come first before personal gratification and personal gain. And if only If only we placed country first. If only we kept to the momentum. If only we kept to the objective. If only we kept to the clarion call that indeed these laws were Jammeh laws, we would not have found them today, 7 years after Jammeh had left the Gambian shores. But the truth is, we saw that those laws were beginning to protect and entrench and help cement ourselves in power. We believe that these laws that we call Jammeh laws, when we sat back and came into power, we looked at it and we saw that we could use those same laws to suppress others that go against us. So all of a sudden, they did not become Jammeh laws anymore. They became the laws of the Gambia. And so you will see people that argue robustly that the laws were bad, that the laws were Jammeh laws, that the war laws were dictatorship under the dictator of Jammeh, and now making the argument that these laws are part and parcel of our laws, and that the 1997 Constitution is the ground up. Is it true? Yes, it is. But it leaves you and I to make our decision and to think the type of leaders we want and the type of country that we want. So like I said, it was going to be a short one. I've got other commitments, but I just wanted to speak on this. And now we would allow and see whether the courts would determine that indeed whatever the utterances of Ibrahim Diba are indeed seditious, and that he would be found guilty of the offense. Or, as we are all hoping, the courts would free him and find that whatever it is that was said was not seditious, especially if the courts would take into account and be fair and look at the political situation in the country, where insults and political attacks, personal attacks, are the order of the day in our political discourse, be it from the ruling government or from the opposition. But I think going forward, we should concentrate more on issues, substance, political changes that would bring progressive and effective emancipation for every single Gambian. And that, I believe, is the right thing to do. I thank you guys very much for joining me, and I wish you all the best. Take care and God bless.